Robert Mutembe.
Let us pray. Our Heavenly Father, in Jesus' name, we are grateful for this day that you brought us together here for this purpose that is ahead of us. Lord, we commit the day ahead into your hands, even as we commit this conference into your hands. We pray that, Lord, you will lead every participant and every person that will be involved in this process. Father, we give you glory and we give you honor. We pray this believing and trusting in Jesus' name. Amen.
Thank you so much. We can take our seats. Mr. Robert Mutembe is the project manager for FOLAP, Faculty of Law Legal Aid Project, which in conjunction with the UNDP Amkeni wa Kenya has made this conference possible. So, Honorable Ann Amadi, Chief Registrar of the Judiciary of Kenya, Mr. Walid Badawi, UNDP representative, resident representative to Kenya, Alexander Baron, European Union Head of Section Governance and Macroeconomics, Egerton University Nakuru Town Campus Principal, Professor Lena Nahone, Professor Patricia Kamere Mbote, Professor of Law, University of Nairobi, Mr. Kituku Wambua, UNDP Amkeni wa Kenya Project Manager, Flora Bidali, Director, National Legal Aid Service, NLS, Professor PLO Lumumba, Distinguished Jurist, all protocol observed, ladies and gentlemen, karibuni sana to the first National Legal Aid Conference, which is being held in conjunction with Egerton University Faculty of Law and UNDP Amkeni wa Kenya. My name is Kioko Wakivandi. I'll be your Master of Ceremony. But actually, it's not my responsibility to invite you officially. That will be done by someone else. And that person is actually our Dean Faculty of Law, who's our host, together with Mr. Wambua Kituku and others. And so without wasting time, then I'm going to invite her to come forward and set us going. Dr. Ruth Aura, kindly. Asante.
To our Chief Registrar of the Judiciary, Madam Anna Madi, Mr. Walid Badawi, UNDP Resident Representative in Kenya, Alexander Baron, European Union, Head of Section Governance and Macroeconomics, Professor Patricia Kamere Mbote, the Principal Nakuru Town Campus, Mr. Wambua Mutuku, UNDP Amkeni wa Kenya, Manager, Professor PLO, Flora Bidali, and all protocols observed. Good morning. I welcome you to our first National Legal Aid Conference, the very first of its kind for the Faculty of Law, Egerton University. But before I proceed, I would like you to meet the faces of the people who has made this conference what it is today, and that is the staff from the Faculty of Law, beginning with our founding dean. Our founding dean, where are the others, please? Where you are? Can you stand? Because without you would not be here. That's Professor Wabwile. Please, can you, Valerie, Kimani? Our founding, can you come to the front because you need to be seen? Our founding dean, Professor Wabwile, and I would just like him to say a word. He's the only one allowed to say something. Professor Wabwile.
Thank you, Dean Dr. Ruth Aura. Mine is just to join you to welcome the delegates to this legal aid conference. As a retired university administrator, I don't have much to say, but just to encourage and urge my successor and my colleagues to do the best and to provide appropriate support and mentoring for the team that has put together the arrangements that we are having today. Later in the conference, I'll also be sharing perspectives on legal aid in the area of children's economic and social rights, child support, and emerging issues. Thank you.
Thank you, Professor. Brian, can you just ensure you have you comply with the MOH guidelines as they come? Brian, can you? Robert. Eric, Valerie, Mr. Kimani, our able administrator, and the others will be joining us. Where is Dr. Sena? Dr. Sena? Yes, Dr. Sena. Dr. Sena is the expert for indigenous, so you can imagine the importance for this conference for him. Okay, thank you. You may take your seat. This workshop is very important for us because it is coinciding with the International Human Rights Day, which is coming up tomorrow. And we know that legal aid is a fundamental human right. And because it is a fundamental human right, not all of us, in fact, the majority of the population, whether in Kenya or in the rest of the world, are not able to access justice in the best way that they can for one reason or the other. You know? And because they are not able to access justice in the manner that is, we always talk about equality before the law. And we can never get that equality before the law when more than 50% of the population face challenges of accessing the justice system. And because there's a challenge, how do we then bridge the gap to ensure that each one of us, the able and the unable, become equal before the law? And because we need to embrace equality for all persons, it then becomes very important for us to embrace legal aid, not just as for the poor, and because it is for the poor, they are begging, So we do not give our all to them. We should take legal aid as something so important and deal with it seriously the way we would deal if those indigent, the marginalized or the poor were to have money and pay us like regular advocates when we take instructions. I will tell you, or even Flora here will tell you, when you go to prisons, the number of remandees there, who do not have representation, or who have representation but they're pro bono. Their cases take very long. Why? Because we don't see pro bono work as something befitting for advocates, and we'll always try to compromise, If Professor Mbote were to hire me and she'll pay me over 100 million, I'll do a case straight away. But if Flora Beidali will give me a client to represent on a pro bono basis, and the amount that she's going to pay me for the entire period is 10,000 shillings. Between the two cases, which one would I run to? Which one would I give my best? But remember, why am I bringing this point here? I'm bringing it because we should see legal aid, those who want to access justice, as people who need justice. And it doesn't matter the amount of money that they are paying to get that justice. We should do our best to ensure that even those who are lacking have support system from somewhere. And the support system can only come from me and from you, and with the support, with the relevant authorities that are supposed to fund the legal aid programs to make access to justice a reality for the marginalized and the poor in the society. Now, I come back to this conference. Now, why we are here is because our faculty, I'm sure you'll be wondering, what will be the Faculty of Law doing with legal aid all the time, going into the community? Because for us, our vision is to see a society that is equal and just. And because we want to give back to the society, no matter our statures, no matter the statures of that person, those needy people who cannot access, the ones for Flora, not the one that I mentioned for Professor Mbote, how do we enable them? How do we facilitate them with information, not always representation? How do we encourage them, when they get a roadblock and they do not know where to go? How can we guide them? And this is the gap that the School of Law, the Faculty of Law, Egerton University, is bridging to ensure that they facilitate the marginalized through empowering them with information to know their legal rights, to be able to claim or reclaim them when they are violated. And even instances where that information goes beyond just advice, we can take up their cases and represent them in court with very minimum fee that we pay to our pro bono advocates, which we have enlisted in our schemes. As we talk here, the Faculty of Law, even though only 5 years old, it has grown its wings within Nakuru County. With the support of European Union and United Nations Development Program, Amkeni project, being headed by Mr. Wambua here, have been very kind enough to boost our vision of this society which is equal and just. Okay? And how did they do it? By supporting us financially, socially, politically, to ensure that we reach places where we can, and especially in the communities. And our slogan, taking law to the people, speaks to our vision. We know that in an advocate, you have to go to their offices. They don't look for clients. But for us here, we go into the community through public forums, we create awareness, and those who have issues walk to us, and we give the information needed. And if they need representation or any other further action that needs to be taken, we do it on their behalf. And that's why we're saying we are taking a lot to the people. We are not waiting for them to come. We go into the community to inspire them, give them the legal information that they need. We tell them where they can go when they have problems. So it is a society that is very informed, and when you have an informed society, then it becomes easy even to challenge institutions, make demands without fear, because you know there's someone who is ready and willing to protect you and walk you to the level where you need to reach. And so we really thank UNDP, European Union, for making it possible for the law school to have this program running and reaching out to the community. For the last 1 year, when the project was launched in 2019, in September, we've worked with different stakeholders. National Legal Aid Service has been a critical partner. We have worked with the County Commissioner's Office. I think they're represented here by Madam Mary. The county government has been very supportive. We work with Rift Valley Law Society through the pro bono scheme that we have established. And so far, we have like about 23 lawyers that have registered in that program, and they help us when we go to the community. We take pride in our students because we've taught them the theoretical. We've taught them, they have a lot of theory in their heads, okay? But we use this legal aid project as a flagship to expose them to hands-on experience and exposing them to the real legal problems that the community are facing, and then they are able to relate that problem with what they learned in class. So even as they create awareness in the community, it's not that we leave them alone. They are guided by the advocates who are in the pro bono scheme and our able faculty staff that take them through the process, first of all, by inducting them into the process of undertaking legal aid as students. And then when they are ready, we take them out to the field. So they are not half-baked, and we do not give the community a raw deal in terms of advice or in terms of representation. And also, in the last 1 year, we've been able to train over 80 chiefs in Nakuru County. And why is the chief important? The chief is important because they're the ones who are living in the community. And remember, they're like the small gods in the community. When they violate the community members' rights, and the communities are not aware of the violations or they fear them, it becomes a big problem. So we need to understand them. We need to teach them to understand their role as chiefs and their role in relationship to the community members, so that even if a violation is reported, they don't victimize the members in the community. And you cannot empower the community with that legal information if the chiefs themselves who are supposed to be serving them are not aware of those rights. So we try to bring a balance in a way that those who are accountable, we build their capacity, and also the right holders, we try to make them aware of their rights so that when they make demands and get this duty bearer to be accountable, then they are at the same level, you know. So then we talk of a society which is equal and just. And then over the last 1 year again, we've been able to train leaders within Nakuru County, about 15 of them, on alternative dispute resolution. And because we find that as an important thing, because not every problem that the society is facing must reach the court. The chiefs solve problems every day on a daily basis in their offices. And sometimes they violate, in the process of solving them, they violate their rights. And I'll give you an example. For sexual offenses, defilement, you'll find some man has defiled a young child of 10 years, and they'll be told, if you don't want this matter to go further, call the parents. And then the chief will call the parent, and then, of course, the culprit, then they compromise the matter in his office. He doesn't know, he's not aware that in such matters, he's not supposed even to mediate. He has no jurisdiction. So we have to bring this to their attention so that even if they want to do mediation, they only do it in specific cases and not others. And even when they are doing, they need to be quite aware of the laws pertaining to the specific issue that they are dealing with, so that at the end of it, someone will not bring an issue. No? So in the mediation, and I'm happy one of the leaders that was trained is here from the County Commissioner's Office. I'm sure she'll tell you her experience with that program and how it has helped them to solve disputes in their offices without people raising eyebrows like it has been in the past. We've been able to reach over 800 people through radio. Over the radio, we've reached over 200,000 people, because the coverage for Nakuru radio that we use is quite wide, you know. Sometimes we go to give talks on topical issues, employment, sexual offenses, succession. You know, someone goes to the radio and then people call and ask questions. We have a toll-free line that you can call and you'll be given advice by either the faculty staff or the students, and it has been running for the past 6 months. So even during COVID, our students, our staff, and the pro bono advocates that we use have been very active, because we got the support from the County Commissioner's Office and from the county government that allowed us to get into the community to reach out to them during COVID time, because there were a lot of violations, and because they were there, they were able to reach out to us, and we found ways of dealing with that issues. We've also done a lot of public forums, just creating awareness, using the churches, again using the County Commissioner's Office, using the community, and reaching out to young girls in the schools and teaching them on how they can cope with life. Now, as I said before, we always see legal aid as something which is not so important and should be left for poor advocates or for people who are unfortunate in society. That is not the point. I said it's a fundamental right, and when something is fundamental, you cannot wish it away. So it is up to us, you and me and the rest out there, to take legal aid seriously, because the harvest is so huge, but there are very few people to harvest. And the harvesters are here. And I'm challenging you to embrace legal aid and to support legal aid. I wish you a fruitful deliberation. Thank you.
Thank you so much, Madam Dean, for that context setting. We could give her another round of applause, please. And with that, then, we can officially recognize the presence of Honorable Anna Amadi, Chief Registrar of the Judiciary of Kenya. And we would also, Madam Karibu, we would also like to recognize the presence of Dr. Gerasimos Foulanos. I hope I've pronounced it correctly. Team Leader, EU-funded PLEAD project. And now I'm going to invite Mr. Wambua Kituku to also set the context, the project manager, UNDP, Amkeni wa Kenya. Karibu, Mr. Wambua.
Okay. Honorable DCRJ, distinguished guests, members of the academia, civil society representatives, representatives from the county government, ladies and gentlemen, my name is Wambua Kituku. I'm the project manager, Amkeni wa Kenya. And I'm here to make two presentations, one on UNDP, one on Amkeni wa Kenya, as a way of also providing a context for this conference. But in the interest of time, I'll just make one consolidated presentation. It's important that we all get to know who is Amkeni wa Kenya, who is UNDP, and why are we co-sponsoring this important conference with Egerton University. So Amkeni wa Kenya is a civil society strengthening project of UNDP Kenya. So we are part and parcel of UNDP's Kenya country office. We were set up in 2008. At that time, if you recall, Kenya was emerging from post-election violence, and peace building and conflict resolution efforts were underway. So the rationale of having Amkeni at that time was to mobilize and facilitate civil society participation in the development and implementation of the National Accord at that time, but also importantly, to ensure civil society voice is heard in the governance, justice, law and order reforms that were happening around about the same time. So since 2008, we've been able to support over 400 civil society organizations with projects in such areas as human rights promotion, promotion of people-centered devolution, promoting and enabling environment for civil society in Kenya, and therefore promoting and enabling civic space for organizations. And lastly, also strengthening civil society organizations' participation in contemporary governance issues like elections, anti-corruption efforts, and the like. So we work through providing grants, providing technical assistance, capacity building, and also promoting learning and knowledge management. So essentially, our support for Egerton through this conference fits within our mandate for promoting learning and knowledge management. So within UNDP Kenya, Amkeni wa Kenya is domiciled within the Governance Inclusive Growth Unit, which is headed by Danjuma, who is here with us today, and he will make the remarks on behalf of UNDP. We fit within UNDP Kenya's program strategy that runs from 2018 to 2022, and the strategy is organized around three priority areas. One is governance, peace, and security. Second one is inclusive growth, structural transformation, and the third one is environmental sustainability, climate change, and resilience. Our work is in the first priority area of governance, peace, and security. And in there, UNDP is implementing projects on access to justice, and Amkeni wa Kenya is a flagship project on that particular issue. UNDP is also implementing anti-corruption, devolution, elections, peace building, as well as prevention of violent extremism in Kenya. But then UNDP's Kenya strategy is also vertically linked to UNDP's global program that also coincidentally runs up to 2022, and accountable governance, where access to justice is also prioritized, is one of the signature solutions. So our work contributes to UNDP's country program, which also contributes to the global UNDP program. But as you all know, UNDP's work is also anchored on the Sustainable Development Goals agenda, and in particular our work directly contributes to Goal 16, which talks about peace and justice. Within the country, UNDP's program is also linked to MTP, Vision 2030 to start with, and access to justice, promotion of Bill of Rights is one of the key priorities under Vision 2030. Under the medium-term plan, okay, yeah, fine, yeah, we can link. Okay, this idea. Okay. As I was saying, yeah, MTP 3, MTP 2, MTP 3 also identify provision of legal aid as one of the flagships for the Kenya government in support of implementation of Vision 2030. So really our work is also grounded in the national development goals of this country. Now, how therefore is Amkeni wa Kenya carrying out work on access to justice? Where is the funding coming from? Beginning 2014, the European Union began consultations on a new program that was aimed at promoting access to justice, particularly for the poor and vulnerable in Kenya. We were part of that consultation as UNDP, and the consultations culminated in the design of a program now known as the Program for Legal Empowerment and Aid Delivery in Kenya, PLEAD. So when PLEAD was eventually signed in 2017, UNDP, Amkeni wa Kenya's project, was one of the co-implementers of that project. So the other co-implementer is United Nations Office for Drug and Control and UNODC. So we were tasked as Amkeni to be responsible for the priority area that focuses on promoting legal aid and access to justice generally. And we work in that area together with the National Legal Aid Service. So UNODC is responsible for supporting other state agencies that have a mandate on this work, like the Witness Protection Agency, the National Council on Administration of Justice, the Office of DPP, and the like. So our component under the plead is supposed to run up to 2022, and we are required to give grants to civil society organizations to provide legal aid, as well as advocate for the full implementation of the Legal Aid Act in 12 counties, 5 urban counties and 7 rural counties that are located in the frontier county region, north and coast. So besides working with civil society, we also working with state agencies or state entities that have a mandate in regulating the work of civil society organizations. And for that reason, we've been partnering with the Council for Legal Education in ensuring that we have a robust framework for accrediting paralegal training programs and institutions in this country. We've also been working with the National NGO Coordination Board, which is responsible for regulating NGOs, just to ensure that we have an enabling environment for legal aid providers in this country. Now, the grants that we give do not just target civil society organizations. We've also reached out to universities, and for the reason that universities not only train lawyers, but they are required to run legal aid clinics. And for that reason, Egerton University was the first university to receive a grant under plead. We hope many more will follow. Having said that, we conceptualized this conference with Egerton University because ever since plead got underway, the organizations that are carrying out this work at the grassroots have encountered new and unique experiences. Leveraging on the mandate of Egerton, which is research, knowledge generation, and dissemination, we saw the need to, at this point in time, provide a platform for harnessing the knowledge that has grown out of the implementation of the various projects under plead. But also, in addition to that, we also saw the need to give scholars an opportunity also to reflect on the same problems which our grantees under plead are grappling with whenever they go out there to provide legal aid, to educate citizens, and also to advocate on an enabling legislative and policy environment for realization of access to justice in this country. So that was the main reason why we came together with Egerton University and agreed to organize this conference. So it is our hope that through this conference we shall have a product that harnesses all the knowledge that we shall share for the next 3 days, and we shall disseminate that product not just to our civil society organization partners, but also to policymakers through plead. I mean, the National Council of Access to Justice will make sure that this product gets to all the actors under NCAJ so that they can see how best to improve their work and ensure that Kenyans access to justice in line with the Constitution and also in line with our obligation under the international law. And with that, I beg to stop here. Thank you.
Mr. Wambua, another round of applause for him, please. Okay. Thank you so much. And you can also get in touch with your colleagues and tell them to follow up the proceedings of the conference online. We are online on our Facebook and website. That's Egerton University. Actually, Facebook and YouTube, what they just need to do is to search the Egerton University handles, both on YouTube and Facebook. And now I'm going to invite Professor Lena Nahone. Professor Lena Nahone is the principal, Nakuru Town Campus College. This is the college that hosts the Faculty of Law. But the beautiful thing about her is that she is the mother of the Faculty of Law. I don't know whether she'll also take that opportunity to tell us that she's actually a soil scientist, but with a lot of passion for law. She will also be representing the Vice Chancellor. Karibu sana, Professor.
Is this true? Aye, but it's okay. Honorable Madi, the Chief Registrar of the Judiciary, Mr. Walid Badawi, the Head of Section Governance of UNDP, not really, yes, Walid is from UNDP, and Alexandra Baron is the Head of Section for the European Union. Professor Patricia Mbote, Professor of Law, University of Nairobi. I know there are many to be recognized, but I want to say all invited guests. Ladies and gentlemen, good morning. I want to welcome you to this conference, which is our first national conference on legal aid in the country. And this has been made possible, as we've been told, by the Dean and by Mr. Mutuku, the support of the UNDP and the European Union under the Mgeni project. I want to sincerely welcome you to Egerton University on behalf of myself as the principal of the Nakuru Town Campus, on behalf of our Vice Chancellor, Professor Rose Monya, on behalf of the Deputy Vice Chancellor, Academic Affairs, where the faculty falls directly under, and also on behalf of the Deputy Vice Chancellor, Research and Extension, where we would squarely put this conference and where we'll want to promote what we are discussing here for future use. Hosting this conference is a great milestone for Egerton University, Faculty of Law under the Nakuru Town Campus College. It takes place, or it places us as a university on a high pedestal as providers of legal education in Kenya. About 5 years since we launched the Bachelor of Laws program at Egerton University. The theme of this conference, strengthening access to justice through legal aid, is apt. It comes at a time when the need to help members of our communities to access justice is more urgent than ever. It is something that has come at the right time, or we have it at the right time. The occurrences, or recent occurrences such as COVID-19 pandemic, continue to increase the need for legal aid. The Dean did mention the aspect of domestic violence, the aspect of child abuse, and we see it every day. In fact, in the recent news, we have seen where a parent is compromised, where a father happens to have made the daughter pregnant and the mother is also pregnant. And the first time he had sexual abuse by the father, their relatives said, let's talk it at home. And I believe legal aid is one aspect. We can eradicate this compromise between either the relatives, the police station, where somebody has committed a crime and they are not, they don't account for it. I'm happy that in the last 1 year, the institution has been at the forefront of legal aid in provision through the Faculty of Law Legal Aid Project, which we refer to as FOLAP. Through FOLAP, we have made it easy for the poor and marginalized in Nakuru County to access justice through mechanisms such as provision of pro bono services, legal aid clinics, and claims or the awareness of the community to claim their rights. So this conference gives us an opportunity to reflect on the successes that this project has made through this FOLAP project, the challenges of offering legal aid, not just through FOLAP, but through other similar avenues in the country. It's an opportunity for you to exchange views and discuss the way forward on matters of access to justice. It is my hope that during this workshop, this conference, that it will be a robust conference. Ideas are exchanged, and they'll be as inclusive as possible, and that at the end, we shall have an output that will shape the justice discourse in this country and in the right way. Now, I would want to almost present it, not really verbatim, by the Vice Chancellor's speech. The Vice Chancellor and the DVCs happen to have a meeting with the Council today to sort out a few issues that we have. As such, they're not able to be available, but the DVC Academic Affairs will be available to talk to us online or via Zoom in the afternoon. As we were told by the Dean, tomorrow we mark the International Human Rights Day. I take cognizance of the fundamental right of access to justice guaranteed in our Constitution and fully appreciate the work done by various legal services providers in Kenya to protect the rights of the poor, marginalized, and vulnerable groups in the society. Kenya, as we are now, legal aid services play a very important role in protecting the rights of the marginalized and enhancing access to the people, or access to somebody who can help somebody. That is a lawyer, but also embracing alternative justice mechanism, which the Dean also mentioned, such as mediation, which is a quick and inexpensive way for us to address justice. As Egerton University, we are very proud to be part of the community of legal aid providers in Kenya. This has been made possible by a robust legal framework, particularly the Legal Aid Act of 2016 and the National Legal Aid Policy of 2015, put in place by the government to promote access to justice for the citizenry in tandem with her constitutional and international obligation. This act also has introduced a collaborative approach that brings on board various actors, including universities, as legal aid providers. Legal aid provision is well within the vision of Egerton University, which is to be a world-class university for the advancement of humanity. It is our desire to transform lives through quality education. The Faculty of Law has done this through legal aid project, which is FOLAP, or we refer to it as FOLAP, with the support of the European Union as well as UNDP under the Mkeni wa Kenya project. So what does this project envision? What is it that we see as being important? This project envisions justice and equality for all. And it is through this project that the university is co-hosting this first National Legal Aid Conference at this venue up to Friday to deliberate on issues of legal aid and access to justice in the country. I wish at this point to thank our sponsors, the UNDP and the European Union, for the important work they are doing in ensuring the marginalized population have access to legal services. It is important for all legal and legal aid service providers that the different levels of governments be involved, and we have here different levels of government. We have the national government, we have the county government represented here, so that we can provide quality and efficient legal services to enhance access to justice for all. This is important in ensuring protection of legal rights for the citizens. As we reflect on the theme of this conference, that is strengthening access to justice through legal aid, we should be alive to the fact that we also have a duty to assist the government in making this call a reality through collaborative efforts and strategic linkages. The legal practitioners, social service providers, the judiciary, Office of the Director of Public Prosecution, which is represented here today, National Legal Aid Service, legal educators, among others, must provide leadership in setting the goals for legal assistance for the marginalized in the society. The Faculty of Law has set the pace and has been at the forefront in providing the needed services to the marginalized in Nakuru County in collaboration with various agencies such as the Law Society of Kenya, Rift Valley Branch, the Nakuru County Government, County Commissioner's Office, the Judiciary, National Legal Aid Service, and civil society organizations, among others. This conference provides another opportunity for engagement with relevant stakeholders for successful legal service delivery to the needy in our midst. You'll all appreciate with the COVID-19, we will find that the number of needy people in our society is increasing and is increasing at a fast rate, and they may not be able to fund for the legal services that they may need. So I urge all participants to use this opportunity to develop innovative ideas and effective strategies for legal aid service provision and enhanced access to justice. It is also important that we consider this as a platform for an open discussion on how the collective efforts of various legal aid service providers can be supported by government. Development partners, that is, we have our government, we have our development partners, as well as other duty providers, for example, the government, to enhance access to justice for all. Once again, I want to thank all of you for finding an opportunity to be here to attend this conference. I want to thank all of you for the support you are giving to Egerton University. I also want to specifically thank the partners or sponsors, UNDP and the European Union, for their support to our Faculty of Law Legal Aid project, and call upon you to make this activity an annual event for learning and sharing experiences. I want to wish you a good stay in Nakuru County, a good stay in Egerton, and a fruitful discussion for the 3 days that you'll be here. Thank you very much. Thank you, everyone.
Thank you so much, Professor Lena Nahone Wati, Principal, Nakuru Town Campus College. Legally, we are here courtesy of Article 48 of the Constitution. I know I'm speaking to 95% of lawyers. But for matters of appreciating the legal framework that brings us here, Article 48 of the Constitution states that the state shall ensure access to justice for all persons, and if any fee is required, it shall be reasonable and shall not impede access to justice. That is just one of the several legal frameworks that make this conference and legal aid in Kenya possible. And now, I now want to take this opportunity to invite someone who we take dearly at the Faculty of Law and at Egerton University, with respect to the successes that not just the project but also the faculty has experienced so far. I'm talking about a personality, someone who was the first national coordinator to legal aid in Kenya, appointed by former President, His Excellency Mwai Kibaki, a great champion for legal aid in the country. And because of the great partnership and support we enjoy as a faculty, we were even given permission by her office to have an embedded legal aid clinic at the courts. And for this, I mean the Nakuru Law Courts. Ladies and gentlemen, I will request you to stand as I invite to the podium Ann Amadi, the Chief Registrar of Judiciary in Kenya, so that then she can also do her context setting or give her remarks, and thereafter we shall go for a break. Karibu sana.
It's the Dean, Faculty of Law, Dr. Ruth Haura, distinguished ladies and gentlemen, all protocols observed, good morning. I'm truly, truly delighted to be here. I think this is the third time Egerton University Faculty of Law is inviting me to one of their many, many events. I do not take it for granted. And it's indeed with great, great pleasure that I join us today as we begin this conference that brings together policymakers, scholars, duty bearers, human rights defenders, social justice centers, development partners, and other stakeholders for deliberations under the theme Strengthening Access to Justice Through Legal Aid. Thank you, MC, for that very kind introduction. Ladies and gentlemen, it has been said that justice is the heart of a successful civil society, and justice is the oxygen of free society. Without liberty and justice for all,
we do not have a life that would be worth living. And this is the reason why access to justice and the right to fair trial is protected under our Constitution and other domestic law and in various international treaties. And a key component to this right is the right to legal representation. As my introducer said, legal aid is very close to my heart. And before joining the judiciary in my current role, I served at the Federation of Women Lawyers, FIDA Kenya, between 2003 and 2008. We had a stint with Dr. Aura there. I served as a legal counsel providing legal aid to women and children. I later served as Deputy Executive Director and Head of Litigation. As has been said, I also served as the first national coordinator of the National Legal Aid and Awareness Program, which is the precursor to the National Legal Aid Service between 2008 and 2011 in the then Ministry of Justice, National Cohesion and Constitutional Affairs. And that makes 8 years of active participation in legal aid on full-time basis. Earlier on, before while in private practice, I did a lot of pro bono work for FIDA Kenya, and probably that's the reason when the organization decided to set up an office in Coast, I was more or less the natural choice for that, and I set up the Mombasa Legal Aid Office for FIDA Kenya. And my day-to-day interactions with Kenyans in need of legal aid and my interactions with the different legal aid providers during this period gave me some of the most fulfilling years of my career. Given this professional background, ladies and gentlemen, and my personal interest in matters concerning access to justice generally and legal aid in particular, I feel greatly honored to have been invited to speak at this very important forum. Thank you, Dean, Faculty of Law, and the rest of the team at the faculty for this privilege. I want to say at this early stage that I'm quite impressed that at just 5 years old, the Egerton Faculty of Law is already taking lead in organizing some of the most consequential conversations in constitutional law today. We are currently at crossroads in our constitutional affairs as we mark the 10th year since the promulgation of the Constitution. We are all aware of the raging debates on the proposals to amend the Constitution, and the Academy is expected to offer a voice of reason to guide and enrich this debate. May I take this opportunity also to laud the faculty for winning against very stiff competition, the partnership with UNDP and Amkeni wa Kenya to provide legal aid under the EU-funded PLEAD project. I'm equally impressed by the faculty's innovative pedagogical approach that focuses on using legal aid to offer hands-on legal education to students. Your active legal aid clinics and collaboration between your students and faculty and with other stakeholders such as the Rift Valley Law Society and the judiciary provide unmatched opportunities for deep learning and mentorship for your graduates, setting them apart in an increasingly competitive career environment. Egerton University is the youngest entrant into the field of legal education providers in Kenya, and by staying this innovative path and remaining faithful to your mission to contribute to redefining quality standards in legal education, I'm confident that you will soon claim your spot among the top law schools in the region. Ladies and gentlemen, discussions at this conference center around access to justice. And at the judiciary, this is at the heart of our transformation journey. Access to justice is the bedrock upon which retired Chief Justice Willie Mutunga's judiciary transformation framework rested, and this has remained the guiding light for our current Chief Justice, soon leaving, David Maraga's own blueprint of sustaining judiciary transformation. Over the past 10 years, we have registered numerous achievements in promoting access to justice. And as we go along, we realize that one of the threats to access to justice is lack of legal information or representation, a concern that is shared by millions of ordinary Kenyans. Ladies and gentlemen, lack of legal information or representation poses significant challenges to litigants in many ways. An uninformed and unrepresented person may altogether abandon what would otherwise be a strong case and continue to suffer great injustice in silence. There are thousands of Kenyans who have genuine legal claims that they do not pursue due to lack of legal information or representation. Self-representation by an average citizen could greatly undermine an otherwise strong case. Pro se litigants are often unable to effectively navigate the maze that is the justice system. They may not be able to ask the right questions to witnesses in court. They may not be able to identify and exploit gaps in the case presented by the opposing side. They may be intimidated even just by the formality of the courts, the technical language, among others. These challenges are more pronounced in an adversarial system like ours, where the primary role of the judicial officer is to weigh the merits of the case presented on each side. Whereas legal representation is enshrined in domestic and international legal instruments, the reality is that professional legal representation remains prohibitively expensive for many Kenyans who come into contact with the courts. This gap has been filled over the years by several civil society organizations who work across the country to offer legal aid services and representation to litigants in both criminal and civil cases, and we're indeed grateful to these organizations. Legal aid for us is not just legal representation and awareness. It also includes the availability of other mechanisms that make it easier for an indigent litigant to navigate the justice system and to receive justice outcomes that respond to their peculiar circumstances. To this end, I'm delighted to share some of the progress that we've made in the judiciary to contribute to legal aid through simplifying legal information and the legal system for the general public. Number one, soon after the promulgation of the Constitution, the Chief Justice gazetted the Constitution of Kenya, Protection of Rights and Fundamental Freedoms, Practice and Procedure Rules, 2013, popularly known as the Mutunga Rules. These rules permit for informal documentation to be used to raise human rights petitions in accordance with Article 22(3) of the Constitution. The overriding objective of the rules is to facilitate access to justice for all persons as required by Article 48 of the Constitution. Ladies and gentlemen, over the years, the judiciary has been running the Pauper Brief scheme, through which thousands of Kenyans have been offered legal representation. In collaboration with the Law Society of Kenya, all suspects charged with murder who cannot afford an advocate receive legal representation. And through this scheme, murder cases have continued to be assigned to advocates who represent suspects at a nominal fee that is paid by the judiciary. The judiciary also allows for the filing of cases by what is called it's a word I don't like. You can file a case as a pauper. so that if you're not able to pay, there is an opportunity for you to go through a process that allows you to file your case as a pauper. And this is a process that has been criticized for being too complex for the litigant who wants to file without paying any fees. The other initiative of the judiciary is that pursuant to the practice directions relating to the pauper brief scheme and pro bono services issued under Gazette Notice number 370 of 2016, the former Chief Justice also issued a directive that apart from the murder trials, all children in conflict with the law must get mandatory legal representation. And this was in response to the tendency of children to win appeals on the basis that they did not receive legal representation at the trial court. And we have been able to facilitate children through collaboration with the Law Society of Kenya. So all children charged with offenses now receive legal aid paid for by the judiciary. Number 4, the judiciary has also made significant strides towards mainstreaming alternative forms of dispute resolution in answer to the call in Article 159 of the Constitution. These alternatives are preferred due to the limited procedural technicalities and their focus on substantive justice. The judiciary's work on formal alternative dispute resolution mechanisms, such as mediation, has so far produced impressive results, and the pilot, which started at Milimani Law Courts, has now been is now being rolled out across all the stations in the country. And in my view, through a properly conducted mediation process, an indigent litigant is more likely to feel aided and less likely to feel re-victimized by the justice system. On the 10th anniversary of the promulgation of the Constitution of Kenya in August this year, the Chief Justice launched the Alternative Justice Systems Baseline Policy and Associated Policy Framework for the judiciary. And this is an important milestone for us as we endeavor towards fulfilling, respecting, observing, promoting, and protecting the right to access to justice through a simple and informal process. Number 5, the enactment of the Small Claims Court and the rules thereof have set the stage for the operationalization of the Small Claims Courts. Ladies and gentlemen, the idea behind the Small Claims Court was to provide Kenyans with a forum to resolve minor disputes in an expeditious and cost-effective manner without being bogged down by procedural technicalities or what we call sharp practice. And this is why the Small Claims Courts Act initially prohibited advocates from practicing before these courts. However, objections were raised against these provisions in light of the constitutional safeguards of the right to representation, which is also enshrined in international statutes. And as such, Parliament amended the Act to allow advocates to represent clients in the small claims courts. Both the Act and the rules developed by the Judiciary Rules Committee provide for simplified processes for filing and resolving small claims, and this will enable ordinary Kenyans to prosecute their cases without the need for legal representation. And that is a form of legal aid to us. In this financial year, we have finalized and gazetted the regulations to guide the operations of these courts, and we have also done the code of conduct for the adjudicators who will be managing and presiding over these courts, and we hope that in the next financial year we will be able financially to roll out the small claims courts. Number 6, to enhance legal awareness, the judiciary undertakes open days through which we engage with the public to help them understand the justice processes and enable them better pursue their legal rights through the courts. The judiciary also produces information and educational communication material distributed through courts to provide relevant information to litigants and the general public. For example, in 2018, the Family Division of the High Court published simplified processes and procedures of inheritance and family law practice. The Family Division also unveiled a simplified code on the adoption process for those who want to adopt children. And both these guidelines were developed with the kind support of IDLO, which has been a steadfast partner to the judiciary and other sector institutions that are constrained by funding. We have also embarked on the process of developing a pro se litigants guide for use by the public. And with that, we also have training manuals that we want to share with the legal fraternity, including the Law Society of Kenya, paralegals. And this pro se litigants charter is being developed with the support of UNODC under the PLEAD project. Once completed, the charter will serve as a ready tool available for all in criminal matters to aid their understanding of the process and to subsequently aid their participation in justice matters. We hope to collaborate with all the stakeholders gathered here to ensure that Kenyans across the country have access to the charter and that all stakeholders receive the necessary training. Number 7, ladies and gentlemen, with the COVID-19 pandemic, the judiciary has had to downscale its court operations and minimize physical court attendance and quickly switch to virtual courts and online platforms to facilitate justice. We have faced challenges with this initiative, but we keep pushing to get it right. But we also recognize that not all litigants possess the wherewithal to participate virtually in these court sessions. You may not have, not all our litigants have computers and laptops and smartphones. They may have the smartphone, but no bundles. So efforts are underway in the judiciary to provide public booths within the court precincts with officers to assist this category of litigants so that they are not in any way disadvantaged by our e-platforms. Funding remains one of the main challenges, undermining the success of our different initiatives, and we reiterate our calls to Parliament to increase the judiciary's annual budgetary allocation so that we can offer this service to all deserving Kenyans. As we ask for more funds, we are most grateful to the lawyers who have sacrificed their time and skills to support our pro bono schemes. We acknowledge that what we pay them is not in any way commensurate with the time, the skills, and effort that they expend in assisting accused persons under the judiciary pro bono lawyer scheme. The lawyers sometimes have experienced delays in processing their payments, a highly undesirable situation, and I'd like to assure all stakeholders that my office is working to streamline these processes. May I also acknowledge that it may be a while before we achieve a system that is as simple and as user-friendly as we would want it to be. The need for legal aid providers will continue to play an integral role towards enhancing access to justice for all Kenyans. I wish to acknowledge the contributions that organizations represented here have made over the years towards improving legal aid in the country. Ladies and gentlemen, one of the objectives of this conference is to facilitate networking and exchanges among legal education providers, civil society organizations, social justice centers, paralegal networks, and bar associations, the Bar Association in their respective role in providing legal aid in Kenya. Indeed, it's my hope that the partnerships that will be forged over the next few days will set us all on a new trajectory as we work towards ensuring universal legal aid and access to justice for all Kenyans. Ladies and gentlemen, I began by recalling my personal and professional interest in matters legal aid. I would like to end on the same note by reiterating my commitment to this cause. Towards this end, our doors at the judiciary remain open to any organization with solid proposals on partnership with the judiciary to expand legal aid to the people of Kenya. I would particularly like to welcome the National Legal Aid Service to join the court users committees in our courts spread around the country, and so that they can spread, so that the legal aid service can spread its footprint across the country. May I also encourage the Faculty of Law Legal Aid Project to join the court users committee in the nearby courts for more learning and for greater partnership. Many thanks to the European Union, the United Nations Development Programme, Mkeni wa Kenya for providing the funding that enabled this conference to take place. I know this is money well spent, and it is my hope that by the end of this gathering, we will come up with concrete proposals that will enable various organizations to offer legal aid in a more sustainable manner. I look forward to fruitful deliberations, and I thank you. God bless you.
Ladies and gentlemen, I think we can do better. Another round of applause to Anna Madi, please. Asante sana, madam. I am a journalist and a journalism trainer at the university. Initially, I said that I'm very much aware that in this room, we have 95% of lawyers. And the others who, of course, who are embedded. I don't know why the Bible likes putting lawyers and journalists in the same basket. When you read the gospel and so on. Waandishi wa habari na wana sheria. Professor Michael Wabwile perhaps will do a sermon on that. But I've really learned a lot myself in this journey of legal aid. And sometimes I see legal aid as the corporate social responsibility of the judiciary, the judicial arm of government. So, asanteni sana. Allow me to just invite you now to a group photo. Let's have a break. We are going to have a group photo as well as tea break. We are going to have the group photo at the entrance where we have the banner. And perhaps by the time we come back, some people will not be there. But then the other announcement we need to make is that there is a registration form that will be at the registration desk. Kindly ensure that you have signed, you have your name in that form, and especially during tea break. So for now, let's all go for the photo session. Just a minute.
Because the chief registrar has a function to attend, and it was really a huge sacrifice for her to be here, I would request that before she leaves, if you have any questions, any comments about what she said, I'll give you 5 minutes to do that. If Honorable Madam Anna Madi will accept. Thank you.
Yes, thank you, the Speaker, Registrar of the High Court, and Dean. When your colleague said he was a journalist, I was thinking he's going to invite us to ask questions. So I was also wondering. But let me just pose just
I'm
one.
representing him now as the next journalist in the future.
Thank you. My question has to do with, I know there's laudable history she has in the legal aid, and she's very knowledgeable, as well as now her administrative powers I want to ask about a decision made about, I think it's even a month has not passed, in Kisumu, where some of our colleagues have challenged the idea that murder cases take too long. So there's no rationale for murder cases being tried in the High Court because magistrates have also studied criminal law and they can as well resolve them. So the aim seems to be, and the decision that was made by Judge of Appeal to be Judge Lesit and 2 other judges, is that the state should rationalize the discrimination between murder trials and robbery with violence trials. Why a capital offense is being tried in magistrates' court as robbery with violence, but murder cases with the same consequences but in the High Court. The worry that we are getting in the profession is we have always argued that it's robbery with violence cases which should be taken up to the High Court so that they can be given legal aid. The one that you have explained is given to murder suspects. Now that they are saying that murder cases will be removed down, we are afraid that they are going to lose the legal aid which they have been having. So in terms of the rationalization and the legal aid, why is it that throughout the years, so many cases robbery recorded assistance through legal aid, yet they are facing the same capital consequences, and now we are worried about and then secondly, in the same tone, there's the issue of, well, I was going to try and mention that other sufferers who need representation don't need it only at the court stage. Even murder suspects need it at police station level. So there seems to be a need for legal aid to be given, not just when the trial is commencing, because much of the case has already started at the taking of statements and so on. So at this stage, I would just like to thank you and leave those as the questions. Thank you.
All right. Asante sana. Anybody else with a comment? Okay. All right. So she can just go on. Just come forward, then you will do the.
Thank you so much, Chief Registrar, for your remarks. My name is Aska. I'm from an organization called Federation of Deaf Women. We are a CSO, and I'm humbly making this request to you because the paralegals and the legal aid, yes, they're out there, but for us as a community, we have that communication barrier. So access to justice for us is even worse. So because we don't even know, like, where do we go? And then sometimes if we have a problem, the communication barrier is such a challenge. Also getting a court interpreter or an interpreter who understands legal terms to come and facilitate that communication is a challenge. So we've not been very happy, and we want to see how can CSOs be involved in terms of making access to the deaf people available.
Good morning, everybody. My name is Catherine Muma. Thank you so much for those very good remarks from the Chief Registrar. My question is about what the judiciary is doing to facilitate access to the 95% of Kenyans who can not access justice through the courts. Your own research with the Hague Institute, the Oslo Institute, I think in The Hague, revealed that the courts are only accessible to less than 90% of Kenyans. And Article 159 provides that opportunity for other mechanisms to be used. And I know you had a task force led by Justice Joel Ngugi to look at this issue. But my reading of that report indicates that we don't seem to have a clear roadmap on how we can work, for instance, with traditional justice mechanisms to facilitate access to justice to the 95% of Kenyans. I know it's a matter of investing resources, more resources in mechanisms other than the courts, and getting greater linkages between the courts and those mechanisms. But I'm afraid, in my reading of those recommendations, I don't see a clear roadmap on how we as a country can persuade Wanjiko that they are an equal beneficiary of the Constitution in terms of the rights provided in the Constitution.
Thank you so much. Anybody else with okay, Asante.
Thank you very much, Honorable Amadi. My name is Dindi. I'm an advocate. And when we are representing clients, many times we find ourselves, with regards to pro bono cases, getting paid at the tail end of a case. And I think one of the challenges that we face, because there are times we have to go really far to assist. We have the heart, we want to assist. And I go regularly to Garissa, all the way to Garissa to assist. But then our disbursements, we need to travel. Is there a way, is it just a practice to be paid at the tail end? Or is there a way in which that can be amended such that at the very beginning, we do not have to worry about something as trivial as transporting ourselves from one place to another to court? Because Dr. Aura mentioned that there are only 23 advocates in the Rift Valley region. I'm not sure the Rift Valley region or in this area that are in the scheme versus the number of advocates that we have currently practicing. I mean, maybe that is one of the challenges, because our disbursements are important. I need to travel from here to there, assist, at times even sit down with the clients for hours on end just to do pre-trial counseling with them in order for them to be able to testify in court properly without them breaking down, without it being a hindrance in any way. So is it a practice? Is it something that we need to advocate for? Can they give us direction on that?
I don't see any other. Okay.
Thank you very much. My name is Dan Juma from UNDP. Just a quick question, and relating this to what Catherine Muma has mentioned. I know the Kenya National Bureau of Statistics has been doing a number of surveys, and the last one they did, I think, on governance, which had aspects of access to justice, was under the 2016 Kenya Integrated Household Survey. But under COVID, they've recently done a number of waves of surveys, and I was just wondering how much leverage the judiciary has over them in the context of COVID to also undertake some studies so that we have some most updated statistics for evidence-based action in terms of how much this COVID-19 has affected access to justice, but even just more importantly, to update some of those statistics that are required for you to make a very strong case in terms of allocation of resources. Thank you.
Okay. I think she can respond to that. Do you want to take the podium, or you want to respond from there? Okay.
Thank you very much for those comments and questions. I'll begin with the decision in Kisumu. I haven't read that decision, but I think there is merit in the argument that if a murder suspect can get legal aid because it's a capital offense, then a robbery with violence suspect should have the same, because the severity of the penalty is the same. I don't know the thinking behind it, because this has been there from, I think we'll need to dig up and find out what the thinking was. But there is merit if the sentences are equally severe, then there is an argument for having the same treatment for both. Why should murder cases be done in the High Court and not in the lower courts, or vice versa? A chief magistrate, a chief magistrate is just a breath away from the High Court. Because if I'm a chief magistrate today and tomorrow I become a judge, today I'm not able to do the murder trial, but tomorrow I'm able to do a murder trial. So it's something that should be food for thought for us, even in terms of resources. We need to have discourse on that. Should we have the robbery violence matters taken to the High Court, or should we have the murder matters brought to the lower court? Just looking at it off the top of my head, we have more resources at the magistracy level compared to the High Court level. Some of the delays that you're talking about are just as a result of the numbers, just the sheer numbers. How many judges do we have to serve the 50 million Kenyans that we are? We have 100 judges and 500 or so magistrates. The establishment for the magistrates in the judiciary is 1,200. We have not even made the 50% mark. So it's an issue of just thinking about rationalizing, but also an issue of resourcing and making sure that we have our resources in the right place. Where do we need them more? So I do not have an answer for that, but I want to take that up for discussion further, not just in the judiciary, but with our stakeholders as well, especially at the National Council on the Administration of Justice level, which brings together most of the stakeholders represented here. Indeed, we need legal aid at the police station, but of course, while at the police station, before you come to the judiciary, we don't know anything about you. You become ours once you have been brought to us. So I think that is for Flora Bidali, National Legal Aid Service. I hope you will have an opportunity to respond to that and tell us what happens at the level of the police station. ASCA, the issue of hearing disability. Whenever we have cases of this nature, we try very hard to avail an interpreter. And what I'd say is I would invite us to partner with your organization so that we see how to do it better. Sometimes it is a challenge to get one quickly, but if we work together, I'm sure there's a way we can respond in a more effective way. Catherine, the 95% who cannot access justice. I was just thinking, who's before you come to the judiciary, is so that we can deal with your access issue. Who do you belong to? But I'd say this, that we're trying as much as possible, first of all, to have courts in every sub-county, just so that the physical spread of courts is responsive to the needs out there. Our AJS framework, your observation is that it does not provide a clear roadmap on how AJS can be applied. This is feedback that I'll need to give back to the team, but I also think that the way to go is to engage with all our stakeholders and find a way that makes sense to the justice outcomes that we require. So that is for us to go back to the drawing board, look at the gaps, and invite our stakeholders to discuss and help us come up with something that works. And as you rightly point out, we are always limited by the issue of funding. A lot of these things are also pegged on on the need for more funds. As you might be all aware, the budget of the judiciary is less than 1% of the national budget. And so we can only do so much, but I'm sure through partnership we should be able to do more. Payment of disbursements for pro bono lawyers. Generally, government does not pay for anything upfront. Those in government, am I right? Yes, government just never pays for anything upfront. But looking at the peculiar circumstances, it is something that we can discuss maybe through our collaboration with the LSK and see how it can be done without putting us in trouble with the procurement and all that. It's just the legal framework that does not allow. So if we have to get an exemption, we have to discuss it, look at what is possible, and then create a framework that allows that. Dan Juma, the statistics. Through our Directorate of Performance Management, we are already carrying out a survey just to see what the impact of COVID-19 has been in the delivery of service. We know that there is a dip in the number of cases we have been able to resolve compared to the previous year. And we know that the backlog has actually increased, just, even without carrying out an assessment. But there is one that is going on, and once we have the outcome, we will be happy to share with our partners. Thank you very much.
Asante sana. I don't see any other hand being raised. Professor Nahoni, you want to? Oh, okay. All right. Sawa. So, since I don't see any other hand being raised. Yeah, it's true. I am a journalist. I'm talking to my brother. I was just following the script that my producer had given me. So, but since my producer, consented to having that discussion, well and good. So now we look forward to the second session. Kindly let us continue observing the COVID safety protocol. I see that Professor Lumumba is still with us. Last time he spoke to us, he gave us a new word. I don't know whether he's going to give us a new word again here. And so on and so forth. That word was kivukamito, right? Yeah, guys have already forgotten because it was Kiswahili. Were it English? So let's go for the photo session, please. Asanteni sana.